class, I'm sorry I couldn't be with you last Friday on September 4th, but this is the lecture, the online lecture, where we discuss the third part of Federalism, Chapter 3 in Bianco and Cannon. So before we begin into Federalism, you've already had your intro on it by Amanda Jones, who is very qualified to work with you all on introducing you to Federalism and probably talking about a lot of what the role of the Supreme Court plays in it. Before we get into that, though, there's something that I want to cover from Chapter 2 that I didn't get to cover, and that is amending the Constitution. Now, your book discusses a living Constitution, the idea that some people believe the Constitution should progress and that the meaning should change as our society changes and as our culture changes. The other idea is the originalist view, which is that the Constitution should be specifically limited to what is stated in the Constitution. And if it doesn't say something specifically, then it can't be implied or drawn from the text. We need to go with what the founders intended. Now, I would say to you that neither one of those matter, and here's why. The founders anticipated that the Constitution couldn't guide us in every single decision and that we would change as a culture. So they created ways to amend the Constitution, and that is found in the Constitution. Now, there's two ways. The first way is this. 2/3 of Congress, that is the Senate and the House, pass an amendment. That amendment then is sent to the states to be ratified. Now, the states can ratify in one or two ways. The first way is the state legislatures can vote on it, and 3/4 of the state legislators have to pass the amendment in order for the amendment to become a legitimate amendment. The second way is, instead of state legislatures, the states call a convention, send delegates to discuss the amendment, and then 3/4 pass it that way. But it's 3/4 of the states' consent. The second way, and the way that is least used, as in it was only used once, is 2/3 of the state calling a convention and passing an amendment. Now, just as before, just because 2/3 of a state call a convention and pass an amendment, that doesn't mean the amendment is law. At this point, just like before, the amendment must be ratified by the states, and in the same way as before. Either 3/4 of the states of the legislatures or 3/4 of the state conventions have to ratify the amendment in order for it to become a legitimate amendment and part of the Constitution. Obviously, we most often use, and by most often I mean always, use the first option where Congress presents an amendment. The second way, where 2/3 call a convention, was of course used once in history, and that was at the Philadelphia Convention. And at that convention, we simply forgot about the current governing document and decided that a new governing document should be implemented. Some scholars say, or at least some argue, that because of that, states are often a little skittish to call a convention for fear that we just might scrap the governing document altogether and just begin again. So, before we get into federalism, amending the Constitution actually links to federalism because the Constitution is full of enumerated powers, specific powers, and those powers are, as I mentioned before, given to the federal government. The Constitution was never meant to, according to the Federalist Papers, apply to the states. They were simply limits and instructions to the national government. So let's define federalism, which I know we've done before, but it's important you get this definition down. Important for life and important for a test, the midterm and the final, and then likely the upcoming quiz that you have. Your book actually gives two different definitions, but they're in general the same. The first definition was what we found in Chapter 1. If you remember, Chapter 1 talks about our government seeking to control effects on factions, or the effects of factions. How can we diffuse power enough so that not one branch, not one level, not one portion of our government can tyrannize the other? And those ways were, number 1, separation of powers, number 2, checks and balances, and number 3, federalism. If you remember, this was actually on your quiz. Our government seeks to control the effects of action in what ways, and these are those ways. Now, federalism is another way to simply divide power. It divides power by allotting different responsibilities to state and federal government. Chapter 3 says this: it's a form of government that divides sovereign power across at least two political units. What is sovereign power? Well, this is important for you to remember. Sovereign power, when you heard it discussed in political science or just in general about government, is any supreme power of an independent state. And a state can be, well, in our case, it is literally the states: Alabama, Nevada, Utah, California. Those are the states, but it can also be an individual entity in another country too. But it's a supreme power of an independent state to regulate its internal affairs without interference, and in this case, without interference from the federal government. So why does federalism matter? Broadly speaking, federalism is a way to more easily feel the common good. We talk about the common good a lot in this class, and we'll even talk later at the very end about the benefits of federalism, but then it has some disadvantages too. And remember that also, it's about a separation of powers. Federalism is again a way to control the effects of action so that one level of government, one source of power, doesn't tyrannize the other power. It's a way to ensure our liberties in the United States. Now, the level of government that oversees a policy can make a huge difference. And this is also why federalism matters. An example would be this particular real-life example, dictating speed limits across state highways, for example, marijuana for medical purposes, same-sex marriages, segregation of schools. Now, we know that schools have been desegregated now for many, many years, but for a while, some states implemented desegregation and some states didn't. Now, if the states had pure control over that without the national government interfering, we would still have segregated schools in states like particularly Arkansas, unless they decided later to desegregate on their own. The same goes for same-sex marriage. For a long time, it was a state-by-state decision as to whether or not they would allow couples to marry that were of the same sex. And speed limits across highways too. That's something that could arguably or should arguably be mandated to be the same across every state just for confusion's sake, so that we're not confused about how fast we can go. There's another example that I like to use. That is, Wisconsin is really prone to have blizzards and serious bouts of snow. The federal government mandated that on the highways or the interstates, the lines defining the sections be white on the interstate. And this was fine for Florida because for Florida, there wasn't hardly any snow ever. So those white lines would always show. For Wisconsin, this turned out to be a problem. Because of all the snow in Wisconsin, many people couldn't see the white lines during most of the year. So there are instances where it does matter who it is that's making the decision at the local level and at the state level. And at the local level, if I say that, I'll generally mean the states. One thing about federalism is that it's certainly an evolving concept. Initially, its boundaries were very clear. But as national government has taken on more responsibilities, the boundaries have become significantly blurred. Now, why is that the case? If federalism is so cleanly defined, and remember our definition of federalism was that each level has its own authority and constitution and are constitutionally equal, and that sovereign power across at least two political units are divided. So then where does the confusion come from that federalism has become so blurred? The Constitution sets specific details to help us determine which level of government has what authority. Specifically speaking, it tells us what the federal government is to do. and everything else is reserved to the states. At least that's what the 10th Amendment tells us, and that's what the Federalists tell us too in the Federalist Papers. An example would be, we know that no state can decide to print its own currency, so there's no question there about whose power that belongs to. The only people that can coin money are the United States Congress. But the powers under the Constitution makes the battle of federalism between who gets what powers, it makes it a little wonky. Remember the types of powers that we discussed in Chapter 2. Now, these types of powers that the Constitution has within them often create some discontinuity of who does what in the levels of government. So remember, those powers are enumerated powers, inherent powers, implied, and concurrent. Enumerated, then, are powers specifically stated in the Constitution. I mentioned before that Congress has the power to coin money. There's no question there that the states do not have that power. An inherent power are powers not specifically stated in the Constitution, but they are logically attributed to a sovereign entity. Example, the U.S. can claim land via discovery or occupation, and the states simply cannot pick up land without discussing it with the federal government. They can't make it a part of the United States. Implied powers are different from inherent powers, although you might get them confused, but they're different in that they're derived from inherent powers or enumerated powers. They're also not specifically stated in the Constitution, though. So, Congress justifies the Affordable Care Act, even though no place in the Constitution does it give Congress the power to create universal health care. However, to regulate commerce, then the Congress can decide to create legislation for the Affordable Care Act under the auspices of trying to regulate commerce. The last form of powers are concurrent powers. These are powers at the federal and the state level can both exercise. An example, both the federal and state governments can tax in different ways, but they can tax. Now, which particular power of the four give us the most trouble with federalism? And that is implied powers. Implied powers have made the division of federalism the most confusing. And I mentioned the Commerce Clause because the Commerce Clause is the one that's most often used to justify the intervention of federal authority into state authority. Now, there are particular types of federalism that we'll go over. The first is this, layer cake federalism. This is federalism in its simplest form and how it was intended to be. It's what the definition says. That there is no hierarchical relationship, so don't get confused there. But each level has its own domain, the national, the state, and this is from your book. The book says that the local government has an area, and usually the states do allow the local government to have quite a bit of autonomy, but remember though that the local government is a subsidiary of the state government. But this is a description of federalism, this layer cake federalism, that the powers are clearly defined and there is no overlap between the powers of the branches, the levels of government. Another type of federalism that I'll talk about later too is marble cake federalism. Now, your book will tell you that we are a mix between marble cake federalism and picket fence federalism. And I haven't talked to you yet about picket fence federalism, so hang with me for a second. Marble cake federalism began during the New Deal. It was the idea that the national, state, and local government can overlap each other in some ways, can work together in some ways. Mainly, the lines that we saw before aren't clearly defined. Now we've got local government canoodling with the national government, state government then with the national government, fiddling with national affairs, and then vice versa. So we attribute this to a marble cake. That is, American politics scholars do. Now, I mentioned picket fence federalism, which is pretty much how it sounds. Picket fence federalism is a type of cooperative federalism. What it emphasizes, again, is not the level of government and the power that they hold, but the policymakers within that given policy area. Those policy areas and policymakers have more in common with the others in their area at different levels of government than with people at the same level of government that work on different issues. So an example would be then, as I mentioned before, agriculture. You'll find that local, state, and federal government officials who work in agriculture are working in that silo effect or in that silo instead of working with their own state government across the different levels. Same goes for national government, same goes for local government. All right, let's move on. Now, these are all, I call these types of federalism. These are all types of federalism, they're all versions of federalism, and this particular picture here comes from, I believe it was another edition of your book, but you have one similar to it in your 4th edition of Bianco and Cannon. This is layer cake federalism, marble cake, and picket fence, and then finally, one that we haven't discussed yet, and I actually won't discuss it till a little later, coercive federalism. The carrot and the stick between the national government and the state government, where the state government tries to lure, the national government tries to lure the state government into doing what they want and aligning their policies with those of the national government. But we'll discuss more of that later. Now, aside from versions of federalism, don't get that confused with what I'm about to discuss with you, and that is the chronological eras of federalism. And your book doesn't discuss much of this. It doesn't go into too much detail, but I would like to. So I'm telling you that these eras of federalism that aren't so clearly defined as I'm making them out to be, but they are important to understand the trajectory that we've taken as a nation in terms of how we view federalism and power between the state and national government. Now we begin then with dual federalism, beginning with the Constitution to about the 1930s. Cooperative federalism then until about the 1960s. Creative federalism until President Nixon. And then we have a series of new federalism, which is mainly broken down by the presidencies. The presidencies have dictated the types of federalism then. So we have new federalism under Nixon, new federalism from Reagan to Bush II, and then new federalism for Bush II and for President Obama, the current president. Let's discuss dual federalism first. Dual federalism is distinct powers for each the state and the national government with very little overlap in activities. Now, I mentioned before that this is from 1787 to the New Deal. An example of this would be the Bill of Rights in the Constitution doesn't apply to people under state law. That may have been confusing, and I can explain. Here's an example that your book gives. Barron v. Baltimore in 1833. A man in Baltimore sued the city of Baltimore for violating the Fifth Amendment. That's taking land without proper compensation and such. So the Fifth Amendment, he evoked that when the city filled his wharf with sand and gravel. So they took his land without his consent. He sued them, saying that this, of course, broke the Fifth Amendment, taking property without due process. The Supreme Court then ruled that the Bill of Rights are meant for congressional laws under the United States government, not for state citizens. So there was a very distinct, there was very distinct difference between the levels of government, the powers of government, who the Constitution applied to, and the Supreme Court we see seemed to back that up, at least up until the 1930s. Other reinforcements of dual federalism by the Supreme Court are the Dred Scott case versus Sanford. So Dred Scott versus Sanford in 1857, saying that the issue with Dred Scott was an issue that was under the auspices of the state and not the federal law. And then finally, there's a group of cases in the 1870s, the slaughterhouse cases. The court ruled then that the 14th Amendment didn't change the balance of power between the state government and the federal government, which is odd to think about today because when we think about the 14th Amendment, that's what's often used to apply the Bill of Rights and anything in the Constitution to the states. But at this point, they said the 14th Amendment didn't change the balance of power, even though the language of the 14th Amendment was aimed at the states. So the liberties expressed in the Constitution apply to the laws passed by Congress. That's that. The second level, or era, of federalism is cooperative federalism that began in the 1930s. Now, what happened in the 1930s? This is directly after the Great Depression. We see here that the solution to that was Franklin Delano Roosevelt's New Deal. His New Deal, in which case it required a lot of cooperation between the state and federal government. And this is where we see marble cake federalism come into play. Because the two levels of government were cooperating, there was, of course, less distinction between whose power was what. And during this era, because of the Great Depression, the states were very dependent upon the federal government for money, generally, and to help the economy. So the states allowed the federal government to do things like provide work programs and provide ways for the states to take care of their citizens. Now, this created a significant shift of power in favor of the national government that we haven't really gotten back to. So federalism, as our specific definition of the book gives it, distinct powers given to distinct levels of government, are no longer in operation from here on out, beginning in cooperative federalism. Your book will also tell us that we're still in an era of cooperative federalism. And that's true for the most part. But there are different eras of federalism that certainly distinguish it from this era, from the 1930s to the 1960s, to later eras. Federalism has been an ebb and a flow. It's not been constant. It's also not wholly been a constant increase in favor of national government. And we can talk about that too later. One more thing before we move on from cooperative federalism to the next era of federalism are that there is a focus on how to efficiently fix problems despite whichever area of government that power belonged to. So the state and federal government said, forget about what power we're both allotted. Let's look at the problems that we have, which at the time was the issues with the economy, the Great Depression, and the fact that the states had no money, and let's do what we can to fix it. One particular new addition to how the federal government interacts with the states is a type of federal aid called categorical grants. And this was firmly established in cooperative federalism. Categorical grants are federal aid given to the states for very specific purposes, and there are strings attached, meaning that if the states don't implement or use the money in the way that they are supposed to be used and implement the program in the way that it's supposed to be implemented, then the money will get removed. The states have no discretion of how the funds are used or how the program's implemented. They simply have to do what the federal government tells them to do. And of course, categorical grants, just like it states, are grants of specific categories given for specific purposes. The next era of federalism, where again categorical grants are also used here, is creative federalism. Creative federalism began in 1960. This is the era of the War on Poverty, the Great Society, Lyndon B. Johnson, right before the Civil Rights Acts. The idea here is that the power shifted again further away from the states to the national government, and it was primarily characterized by grants and aid, specifically what we just discussed, which was categorical grants. Now, what made this era different from the previous era, that is, cooperative federalism, is that Lyndon B. Johnson got a little creative in how he implemented these new programs, these new nationwide programs that would be implemented from specifically the states. Oftentimes, he would bypass the state governments altogether and provide grants specifically for the local governments. And mostly this was involving programs like poverty. Then at that point, the states had very little control then. The local government had now a direct relationship with the federal government, even though they are subsidiary of the local government. even though they're a subsidiary of the state government. Now, let's move on. The next era of federalism began with Nixon. All of the eras of new federalism that you see listed in front of you are, in general, supposed to be the national government trying to give more power back to the state governments, and some succeeded and some didn't. Now, Nixon didn't do the best job, and here's why. His attempt to return to dual federalism included his general premise was using general revenue sharing. Now, general revenue sharing is intended to give states more control over funds from federal government. Congress then would appropriate federal tax revenue to the states. Unfortunately, this couldn't be financially sustained. So overall, it did little to bring back dual federalism. The next era of federalism is new federalism from Reagan to Bush II. Now, the main component of this new federalism was block grants. And block grants were the first real move back to dual federalism. These were federal aid given to states to be spent on a specific policy area, and oftentimes the specific policy area was quite broad. But the state can determine how to spend the money and how to address the money. So it gave the states a significant amount of autonomy. This era of federalism was what we call an era of devolution through the creation of block grants, which I just mentioned. Devolution meaning then the return of policy power and responsibility back to the states. And H.W. Bush and Clinton carried on Reagan's policies. President Clinton specifically brought welfare back to the states by creating PERORA, an acronym for the Personal Responsibility and Work Opportunity Act. That was a block grant created to give to the states so they can have more control over the welfare of their citizens. And another thing he did was stop unfunded mandates. Now, we'll discuss unfunded mandates in a moment, but the Unfunded Mandate Reform Act of 1985 made it difficult for the federal government to impose unfunded mandates on the states. Very quickly, the federal government would then tell the states to do something and then wouldn't give them the funding to do it. So the states had to comply, but they didn't have the money to comply. And President Clinton helped stop this. The last era of federalism, then, is new federalism with Bush II, to President Obama. So it's from the second Bush era to present. Now, this new federalism differs from the previous new federalism descriptions that I gave you in that it's actually most characterized by creative federalism. Remember, this was the era of federalism beginning with the War on Poverty, LBJ's attempt to address national problems in a national way, even not paying attention to the levels of power between the state and national government. So in general, this era of new federalism took power away from the states. An example of this would be the Patriot Act, No Child Left Behind, the Affordable Care Act, meaning there were fines and penalties to those who don't comply. It was an era that distinctly exerted national authority. Now, let's go back to unfunded mandates. An unfunded mandate is a federal law that requires to implement costly federal laws without funding needed to implement the laws. I go back to unfunded mandates now because the No Child Left Behind Act is a good example of an unfunded mandate. The Clean Air Act is also another example. And the Americans with Disability Act is a good example. So let's begin with the Clean Air Act of 1963, which created air quality standards, but again, no money for the states to meet these requirements. The Americans with Disabilities Act in 1990 created all of these new standards for access to all public buildings, which we all agree was great, but again, the state institutions were expected to pay for these changes and comply with no funding from the federal government. Finally, the No Child Left Behind Act in 2001 required statewide standardized testing to assess education quality. If the tests weren't good enough, better teachers then should be hired. And if the school didn't show an adequate step towards improvement then federal funding would stop. So they were asked to create a better teaching environment or a better educational environment for the children of the state, but they didn't have the money to do it often. And then in the cases where they had a more difficult time doing it, the federal funding would end up being taken away. Now, all of this that I mentioned before is a type of fiscal federalism. You can follow fiscal federalism along with picket fence federalism, layer cake federalism. This is simply a description of a type of federalism. So this federalism describes the transfer of money from various levels of government. It could result in a stronger degree of federal power, or it could also result in a stronger degree of state power too. So in cooperative federalism then, categorical grants were a type of fiscal federalism. We see then that that's resulted in a stronger degree of federal power over the states. And then in new federalism under Nixon, we had general revenue sharing. And of course, we had block grants under Reagan, all of which were intended to give power back to the states. Now, there's another description of federalism that describes a type of federalism that could have been used, and has been used in any of these eras of federalism that we just discussed. It's called coercive federalism, and it sounds about as bad as it is. It's characterized by the federal level forcing the states to change policies and policy goals to match those of the federal government. Now, how do they do this? Federal preemption, which is simply just an implementation of the Supremacy Clause. Another way is through regulations, like the EPA and the Clean Air Act. Any kind of regulations that anything that regulates the behavior of individuals within the states. And then we have mandates, and we already discussed unfunded mandates. Another way that the federal government forces states to change policies and policy goals to match those of the federal government are conditions, or your book describes them as threats even. That is, when the federal government wanted to raise the drinking age to 21, they recognized it was a state power. So they told states that they could or couldn't implement the 21 drinking age. The condition was that if they didn't implement it, then they wouldn't receive federal highway funds. Obviously, states complied. So now we have all these versions of federalism, and what you see in front of you are the versions of federalism that were listed in your book. The more prominent ones: layer cake federalism, marble cake, picket fence, and coercive. Now you'll also notice that on page 84 in your book, when it talks about the evolution of federalism, they also mention fiscal federalism too, which is something that we discussed. And fiscal federalism can be used, again, for state power or for national government. So it can be used in any of these types or versions of federalisms. And these versions of federalisms we see, or we have seen, in the eras of federalism that we just discussed. Coercive federalism is described, and I haven't given you a picture of that yet, in the bottom, as the carrot and the stick, where the national government attempts to lure the state governments via a carrot or a stick to do what they want them to do. Now, how have the states responded to all of these changes in federalism? One of the ways, well, most Americans, we'll begin with this, most Americans like having clean air, a fair legal process, safer highways, access for those with disabilities, the Americans with Disabilities Act. But most Americans also trust or feel a closer attachment to state governments, not national governments. Even when acts are passed during a time of war, and oftentimes citizens will allow the national government to infringe on a lot of liberties in times of war. But even when acts are passed during time of war, like 9/11, the love for the national level and their influx into state authority is very short-lived. All right, so now the state's response. I have here environmental standards, statewide health care, nullification laws, rejecting all sorts of kinds of laws. These are all both good and bad. Well, yeah, in general, good and bad. Now let's talk about environmental standards. I listed environmental standards because some states actually chose to exceed the expectations of the EPA and what the federal government recommended. So the federal government would recommend changes for environmental issues, but the states felt that the federal government was not doing enough, and as a result, they made more laws about carbon emissions and having to get the emissions of your car tested, like in the state of California. So then they exceed the expectations of the state government or the goals of the national government, excuse me. The states exceed the goals of the national government. And environmental standards are a good example of that. Another unexpected example, but I'm sure you all know, is statewide health care. Prior to the Affordable Care Act, Massachusetts implemented a statewide health care plan in 2006. They required a minimum amount of insurance coverage, but they also provided health insurance for those who were 150% below the poverty level line. And you probably know also that the Affordable Care Act was modeled after the Massachusetts statewide health care plan. I mentioned nullification laws. These are laws that states implement, and many states have, where states can and must refuse to enforce unconstitutional federal laws. Now, what might those laws be? Well, rejecting federal gun control laws is an example of that. Kansas passed a law where federal gun laws don't apply to guns manufactured in that particular state. Many states have decided to reject the Common Core requirements in education. Specifically, Texas, Illinois, Indiana, South Carolina, they've all passed laws rejecting the education's Common Core. Montana, Arizona, West Virginia, New Hampshire, they're all about to follow suit. Other states have passed laws, but they were vetoed by the governor of the state. And many states then have rejected aspects of the Affordable Care Act by suing the federal government or literally passing laws that said no state official in their state can, for example, impose the fine that the Affordable Care Act had in the actual statute. If you didn't have health insurance, then you were fined. And many states have passed a law that no state official in their state can actually enforce that, and that if they did enforce it, they would be violating state law. Now let's discuss then the court's role in federalism. That is the U.S. Supreme Court, because the Supreme Court acts as an umpire to determine the balance of power between state and federal governments. We've already mentioned many Supreme Court cases that have affected whether or not states have additional power or the national government have additional power. So they help determine, again, the balance of power between the state and federal governments. Now, one of the first things that you might ask is, what about the 10th Amendment? So the 10th Amendment says that powers not delegated to the U.S. by the Constitution, nor prohibited by it to the states, are reserved to the states respectively, or to the people. Many scholars, though, have asserted that the 10th Amendment actually did nothing to protect or alter the distribution of powers between the state and level governments. Yes, many scholars agree that the 10th Amendment actually did nothing, and here's why. Just simply an example. So, in the Constitution, it doesn't say anything about education. So, we assume then, because of the 10th Amendment, and because of the general reason that the Constitution was created, that those powers of education were given then to the states. So that's under state control. All right? If the federal government passes a law through an implied power that they can, but if they pass a law about education, then we have here a federal law against a state law. And what happens whenever two laws conflict? Well, the Supremacy Clause within the Constitution tells us that the Constitution and the laws of Congress are the laws of the land. So, at that point then, public education is no longer reserved to the states. So all it takes then is the federal government trying to find a justification to get into a sort of power that's generally reserved to the states in order for them to maintain a pretty good foothold in that area too. And we see that public education is a really good example of that, especially with the implementation of No Child Left Behind and the Common Core recommendations, the Common Core requirements. Minimum wage was an issue reserved to the states. That is, until the national government imposed a national minimum wage. They did this under Regulating Commerce Clause. So in this instance, the court ruled in favor of the national government. This case is called Garcia versus San Antonio Metropolitan Transit Authority. So now the states can't set their minimum wage. They can increase it if they want, but they have to have a minimum wage that is cohesive with what the federal government sets. So then that power, once reserved to the states, is now taken away and given to the national government. Now here's an instance where the Supreme Court actually took the 10th Amendment and ruled in favor of it. This is an instance where a woman tries to hurt her husband with a dangerous chemical. She was prosecuted, but she was prosecuted under federal law. This federal law was supposed to limit the spread of chemical weapons. So she sued under the 10th Amendment, right? That she was under the power of the states. The Supreme Court actually ruled in her favor. They said the federal government was overreaching, and Justice Kennedy determined that federalism, just in general, and he was hearkening back to Madison here too in the Federalist Papers, but the federalism was more than just setting the boundaries between the state and federal government in these institutions. It's about providing citizens with freedom. So if you recall, we talked previously about why federalism mattered, and it matters in terms of protecting our liberties. Protection from the government, whether it be the state or the federal government. So this particular Supreme Court case, Bond versus the United States, said that the 10th Amendment applied not only to states, but it applied to individuals as well. So here it seems that the 10th Amendment would have a little bit more power. Now let's talk about the 14th Amendment, because the 14th Amendment is often used to overcome any state authority. The 14th Amendment: all persons born, naturalized in the U.S. and subject to jurisdiction are citizens of the U.S. and the state they reside. No state shall make or enforce any laws which shall abridge privileges or immunities of U.S. citizens, nor shall any state deprive any person of liberty or property without due process of law, nor can they deny any person within its jurisdiction the equal protection of the laws. Now at first, in the era of dual federalism, we see that the Supreme Court narrowly interpreted the amendment. So we have states barring African Americans from voting with things like literacy tests before the Voting Rights Act of 1965, and the Supreme Court was allowing that to go on because the 14th Amendment again applied to the Constitution, or well, pardon, the national government, not the state governments. But then we have, in this instance, another case, the City of Bourne versus Flores in 1997. We have an archbishop here in San Antonio wanted to enlarge his mission-style St. Peter's Church. It was a 1923 church in Texas. He wanted to make it bigger, but it was a historic district. And so the local authorities wouldn't give him a building permit. Recently, Congress passed the Religious Freedom Restoration Act of 1993. Now, they did this as a response to a recent Supreme Court decision where the Supreme Court actually ruled that peyote, the use of peyote for Native Americans, is still not legal. Well, the use of peyote for Native Americans is a religious experience. So Congress then was lobbied to pass the Religious Freedom Restoration Act of 1993. This was a congressional act that required very strict scrutiny of any government causing a burden for any institution or any person to exercise their religion. So if a government caused a burden for the exercise of religion, then there needed to be a good reason, a really good reason for that to be, for that law to then apply. So it was under the Religious Freedom Restoration Act of 1993 that the Archbishop then sued. He said that not allowing to enlarge the St. Peter's Church was actually causing a burden on him, this law about the Historics District. So then Congress passed the act under the 5th section in the 14th Amendment, saying that they had the power to enforce, by appropriate legislation, the provisions of this article. Now, Remember what the 14th Amendment says: liberties given to citizens. Part of those liberties are the freedom to express their religion. In tow with that, that's why they passed the Religious Freedom Restoration Act of 1993. This particular law that they passed was a type of remedial legislation. It's in your book. It says that national laws that address, it's any national law that addresses discriminatory state laws, and that's what they were trying to do here. But the Supreme Court ruled that they couldn't implement that law because it conflicted with what the Supreme Court had already ruled. So it has to comport with what the Supreme Court already ruled. What about the Commerce Clause? Well, the Commerce Clause is the clause that's most often used to justify federal encroachment into state authority. But we do have instances where the Commerce Clause, and your book lists them, were debated at the Supreme Court level. The court then ruled in favor of the state government. But there's also many more instances like the Affordable Care Act where the Commerce Clause was used as the justification for state encroachment. For national encroachment into state laws. The Commerce Clause today is more for the use of the national government. But if you look at the Supreme Court cases that your book points out, sometimes in favor of the state government, sometimes in favor of the national government, your book kind of focused on a lot of those that were in favor of the state government. So then what does the United States Congress have in their arsenal to fight back for power? Because remember, ambition counteracting ambition, our founders intended for the levels of government and for the divisions of power within each level of government to want to fight for power. So what are Congress's options? Well, they have two options, particularly in the example that I gave above of the Religious Freedom and Restoration Act of 1993. Congress can pass new laws to clarify legislative intent because, remember, it is the job of the Supreme Court to interpret laws, and often they use to interpret laws as legislative intent. If Congress is explicitly clear of legislative intent, then the Supreme Court has no wiggle room to only side with Congress and what Congress intended. All right, the second option that Congress has to fight for power is to impose will on the states financially by, for example, withholding money. Now, we talked about this whenever I mentioned states raising the drinking age to 21, and if they didn't, then they didn't get any highway funds. Federalism is important for just in general the diffusion of power, but there are benefits and there are disadvantages to federalism. And now when I'm talking about federalism here in this particular instance, I am talking about federalism in its sense, that is dual federalism, how our founders intended it. Now, what can federalism do? Your book gives several examples. I'd like you to use these that I list right here. They're essentially what your book uses, but they're a little more clear. The first is, it permits the diversity and diffusion of power, meaning that people who are different can live in areas where their culture or their desire for particular laws are more upheld, like people who want to live in a county that's dry or people that want to live in a county that's wet in terms of alcohol. Number two, local government can handle local problems better. And we've talked about this with the common good. Common good is best felt the closer you can get to the people. The fewer people that you have to please, the better it is that you're going to understand and achieve what the people desire. Number three, there's more access for political participation. You may not be president, but you may be on your city council or your school board. So there are more ways at the local level to get involved politically. Number four, and this is one of the major benefits of federalism, that it fosters experimentation and innovation at the state level. So we have different states here who can try out things. For example, Massachusetts trying out the statewide health care. Well, it worked well for them, according to some people. Some people might say otherwise. A better example would probably be schools. A lot of states want, or a lot of parents want the ability to send their children to schools despite what district they live in, including private schools. So some states implement vouchers, allowing parents to have the option to send their children to private schools instead of the public schools that are nearby. So it creates competition among education. Different schools want to be the best of its kind. They're not stagnant in how they teach. They are constantly trying to be the best school so that they get the most kids and the most money. All right, so these are all benefits of federalism. Well, finally, and this is one of the most important, the state provides important check on federal powers. Well, the same goes for the federal government, correct? All right. Now, there's some disadvantages to federalism as well. And again, here I've deviated from your book some because I think some of these were worth separating. The first one is it makes national unity difficult to achieve. And this reminds me of the Articles of Confederation and how instead of identifying as a United States citizen, we then have individuals who identify as an Arkansasier or an Ohioan or a North Dakotaan. They identify more closely with their states. So if there is a national issue or a national policy, unity among the nation is really difficult to achieve because people are more so attached to their local areas. Second, state governments may resist national policies. Well, we saw this with segregation or the desegregation of schools. The National Guard had to be called into Arkansas to make them comply with the new national rules. Under the Articles of Confederation, state governments resisted national policies many times. But the state government didn't have any authority to prevent them from resisting national policies. So, of course, some authority is needed, some coercive power is needed. Otherwise, you have a bunch of states running rogue. Number 3, federalism in its purest form can prevent racial discrimination or income inequality. So, income inequality in that you're going to have poor states and rich states, and racial discrimination in the way that I described, for example, Arkansas being able to continue to run with their schools being segregated. Number 4, law enforcement and justice can be uneven from state to state. Now, this is actually true, and it happens. And I think it speaks for itself for what it means. Some states have stricter laws in particular areas than others. Finally, smaller states may lack expertise or money, and this is equivalent to number 3, income inequality. So the states that lack expertise don't have the money to get expertise to do things like try to boost their economy by bringing in new businesses. You know, if they don't have the tax benefits or if they don't have what lures those businesses to go and set up in their state, then they'll constantly remain poor, and the richer states will get richer, and the poorer states will get poorer. So it's a cyclical effect of a lack of expertise and a lack of money. One of the big discussions between the Federalist and the Anti-Federalist was whether the federal government should fear the states or whether the states should fear the federal government. And of course, there was some discord among who should fear who. I'll go to the address and reasons of dissent of the minority of the Convention of Pennsylvania to their constituents. Now, this is the Pennsylvania Ratification Convention. They've gotten together to ratify the Constitution. And the minority lost, obviously, because Pennsylvania ratified the Constitution. But the minority wanted to address their reasons of dissent. And here's one of the things they said. The legislative power vested in Congress by the foregoing recited sections, and previous to this, they actually listed out reasons why the legislative power is extraordinarily strong. So to start again, the legislative power vested in Congress by the foregoing recited sections is so unlimited in its nature, and may be so comprehensive and boundless in its exercise that this alone would be amply sufficient to annihilate the state governments, swallow them up in a grand vortex of the general empire. So the states would just become nothing, according to the minority at the Convention of Pennsylvania. Now here's the Federalist response to that. They actually responded to that a little earlier because it was constantly a discussion of whether or not the federal government was so strong that the states would be swallowed up. And here's what they said. The powers delegated by the proposed Constitution to the federal government are few and defined. Those which are to remain in the state governments, they're numerous and indefinite. The former will be exercised principally on external objects like war, peace, negotiation, and foreign commerce, with which the last, power of taxation, will, for the most part, be connected. Now, the powers reserved to the several states will extend to all objects in which, in the ordinary course of affairs, concern the lives, liberties, and properties of the people, and the internal order, improvement, and prosperity of the state. Now, Federalist 45, this is one of the biggest concerns, are the states not having any authority whatsoever, and the federal government simply becoming just a powerful central authority. And individuals didn't want that. The states didn't want that. Madison begins Federalist 45 saying, having shown that no one of the powers transferred to the federal government is unnecessary or improper. So again, he's saying here, everything that we've done here, every power that we've given to the national government should be given to the national government. We've decided that. It's necessary, it's proper to give these powers to the national government. He goes on to say, the next question should be considered is whether the whole mass of them will be dangerous to the portion of authority left in the several states. And Madison and Hamilton both famously said that, if anything, the national government should fear the states because they could rise up at any time and overtake the national government, which we see is actually probably not the case. But federalism, because of the benefits and the disadvantages, because of why federalism is important, which we discussed at the beginning, still remains an important part of protecting the freedom and liberties of our citizens. So it's constantly going to be evolving. There's going to be an ebb and flow of national and state power. And the hope is, at least for citizens, that that balance of power never gets upset too much so that tyranny from one level of government over the other one will be realized. To be clear, we don't want tyranny. So, thank you all for listening. This is the end of September 4th lecture on federalism.